everyone who is watching, who's logged in and wants to learn a little bit more about English law this evening. First, before I get going, I should say a couple of thank yous. First, to Moscow State University and Alexander Molotnikov for giving me the opportunity to speak. Also, I should thank Irina Voronina for sorting out the logistics, talking me through Zoom as someone who is not particularly technologically adept. And finally, thanks to all of you for taking the time on a Friday evening to come and listen. So what I want to speak about this evening is the title of my slide, COVID-19 and the Common Law, number one. Number one being that today I want to focus on English contract law and basic concepts of English contract law and whether any of them are accessible to parties to contracts in light of events that are happening in the world right now. So I've constructed a scenario that the basis of it changes slightly as we go along and go through the talk, but that is the basic framework within which I want to address the questions that we're going to raise. So there are four broad areas I want to talk about this evening. Formation. So what formalities are there as a matter of English law in terms of forming a contract? Interpretation and implication of terms. Once you have a contract that's written down, how do you go about interpreting it? What does it mean? What are the obligations? Is there any way the parties can say that there's an obligation that isn't written down in the contract? And what are the tests for those things? Third, how do parties go about varying or changing their contractual obligations? And I've put those two things, variation and rectification, together. They are in fact quite different topics, but you'll see in the scenario that we're setting out that we approach it in a sort of similar way. Variation, very briefly, is changing a contract to mean something else, and rectification is where a party is ultimately saying, well, it always meant something else, and we're going to the court now to change the words and get it to reflect what the parties always intended. The fourth thing I want to talk about this evening is frustration, which there have been a lot of notes by law firms, by sort of distinguished academics, kind of talking about frustration, the common law in the context of COVID-19. So that's the broad framework of what I want to talk about this evening. With that in mind, we can get started. The preliminary question, though, I put here, and this isn't being facetious, but I sort of ask this: English law is often preferred because it provides certainty to the parties. But how certain can it really be if appellate judges in England have to repeatedly restate what the law is? And we'll see that as we go through, that actually there is a tension as a matter of English contract law, English commercial law, as between an approach that favours certainty and holding people to the words of a contract that they enter into, and an approach that is can more be characterised as fairness and say, well, whatever the words say, how do I as a judge now, in the circumstances that have happened, how do I approach this and generate the result via a judgment that is fair? So turning first of all to the question of formation. So I've put a basic scenario here between two Russian businessmen who meet in a restaurant in London. So Mr. Ivanov and Mr. Borisov. As I say, they're friends and they are both successful businessmen. They go for dinner together at an expensive restaurant in London where they drink wine and tell stories. Before coffee, however, Mr. Borisov's tone changes. He tells Mr. Ivanov that because of COVID-19, his business is short of cash at the moment, and he asks his friend if he can help him out. Of course, my dear Borisov, comes a reply. How much do you need? To which Borisov says, well, maybe $3.5 million. Ivanov says, not a problem, my friend. Between them, they pick a menu off the table, turn it over, and on the back of it, they write down very briefly what they think the repayment terms of this loan are going to be. Going to repay quarterly. It's going to be a term of 1 year, and it's going to be 3% interest. So that's all that. They carry on, they drink brandies, and they taste their friendship. At the end of the evening, Mr. Borisov picks up the menu, puts it in his jacket pocket, and they bid each other good night. Mr. Ivanov wakes up the next morning with a horrible headache, understandable, he's been drinking wines and brandy, and a text message from his friend asking that the money be paid into his bank account within the next 24 hours. So the questions I've raised here are two at the moment. Is there a valid contract? And related, can Mr. Borisov seek performance of it? Can he force his friend to pay him the money? On the flip side of that, what defenses, if any, does Mr. Ivanov have to this charge that he is now in under a contractual obligation to lend his friend $3.5 million? So the starting point here is to ask what the requirements are as a matter of formality to form a valid contract under English law. And I put a case here, McInnes and Gross, as Mr. Justice Coulson, I think, who said at paragraph 81, a contract can be made anywhere in any circumstances. And that is a fairly orthodox statement of the principle that as a matter of English law, there are very few formality requirements to form a valid contract. Now, that changes if the type of contract, the type of document that you're memorializing the agreement changes. So deeds, for example, have particular formality requirements, as do sort of other forms of formal transactions. But let's keep this at a high level of generality. A basic contract, which, as is set out here, can essentially be made in any circumstances. And like with Mr. Borisov and Mr. Ivanov, in McInnes and Gross, this was an agreement. This case was all about an agreement, or whether there was an agreement, conducted over dinner at a restaurant. Now, there's a broad principle here as to contractual formation that is set out in this passage by Lord Clarke. And he said the general principles are not in doubt. I'm going to move my screen slightly. The general principles are not in doubt. Whether there is a binding contract between the parties, and if so, upon what terms, depends on what they have agreed. It depends not upon their subjective state of mind, but upon a consideration of what was communicated between them by words or conduct, and whether that leads objectively to a conclusion that they intended to create legal relations and had agreed upon all terms which they regarded, or the law requires, as essential for formation of legally binding relations. Even if certain terms of economic or other significance to the parties have not been finalized, an objective appraisal of their words and conduct may lead to the conclusion they did not intend agreement of such terms to be a precondition to a concluded and legally binding agreement. So to distill that down, what Lord Clarke is saying is, first of all, it doesn't really matter what the parties subjectively agreed. You've got to look objectively to the words and the conduct. And it's not determinative that there may be key terms that are missing. As long as the basis of an agreement is there, then there may be the basis for saying that there is a legally binding contract. And that's all well and good. But how do we apply abstract principles more generally? Now, the case that I've thought we'd go through in this regard, which is quite a fun case, is the case of Mr. Blue and Mr. Ashley. Now, the best summary I've found of this is actually from the Times report at the time. So Mike Ashley is a British billionaire businessman. He owns a company called Sports Direct, which makes it sells sports clothing through sort of big discount stores. He owns Newcastle United Football Club, in addition to a range of other business ventures. And it's fair to say, as you can see from this picture of him, that he is a colourful personality. And as you can see from the article, he conducts his business in a slightly unorthodox way. So it says here, Mike Ashley, Sports Direct boss, drank 12 pints and vomited at meeting. And then we see underneath the text, the sportswear tycoon and Newcastle United owner Mike Ashley vomited into a pub fireplace during a management meeting in which he drank 12 pints with vodka chasers, according to a finance expert statement made in the High Court yesterday. Jeffrey Blue, a former investment banker, is suing the billionaire retailer over a contested agreement allegedly struck during a drinking session in 2013. Mr. Blue, who claims that Mr. Ashley promised him £15 million to raise the share price of Sports Direct from £4 to £8, said the meetings of senior management were often held in informal settings, such as the Green Dragon pub in Alfreton, Derbyshire. So that is the introduction to the case. It was actually, it's gone through to trial, and there is a judgment in it now, which is actually, it's a judgment that's worth reading for anyone who's looking for an introduction to the principles of formation as a matter of English law. This is this quoted text is from paragraph 1 of the judgment, which frames the job that the judge was having to do here, the question he was going to have to answer. The judge said, the question in this case is whether, as a result of a conversation in the Horse and Groom Public House in Great Portland Street, London, W1, on the evening of the 24th of January 2013, a contract was made between the claimant, Mr. Jeffrey Blue, and the defendant, Mr. Michael Ashley, under which Mr. Ashley owes Mr. Blue £14 million. Now, turning to the case, the background facts of the evening of the 24th of January are set out in the judgment at paragraphs 10 to 18. Now, I'm not going to read that out in great length, but it's worth highlighting a few points. So around 6 o'clock that evening, various people met in the ground floor of Mr. Ashley's business offices, Sports Direct in London. They sort of made their introductions and then walked across to a nearby pub, the Horse and Groom. The plan originally was to meet for half an hour or an hour for a chat. But what actually happened is they stayed for quite a while and drank quite a lot of alcohol. It's not important, but various people sort of estimated that during the course of the evening, people were drinking sort of between 8 to 10 pints of beer, along with other drinks being consumed as well. Now, essentially, there were various conversations going on, various discussions, sort of light-hearted, sort of jocular discussions about sport, all the rest of it. And at that point in time, the share price of Sports Direct was trading around £4 per share. And it was sort of, the topic came up as to what would happen if the share price in Sports Direct went up. And so the topic became, how does Mr. Ashley incentivize Mr. Blue to increase the share price of Sports Direct from £4 upwards? And there are various kind of comments as to, in the evidence, as to what was said, what wasn't said. But essentially, it was ultimately agreed that Mr. Ashley said, well, look, I'm going to make a lot of money if you get the share price to £8, so of course I'll give you a reward. And so that's the factual background here. And Mr. Blue went away, and he thought that there was a binding agreement formed this evening. And as things happened, the share price of Sports Direct eventually did creep up to £8 a share. So Mr. Blue seeks to enforce this agreement he believes he has with Mr. Ashley. Now, the question arises, well, in the context of lots of drinking in a pub, was this actually a contract formed? And I've set out on this slide, there is a good review of the law as to how contracts are formed as a matter of English law at 49 to 62 of the judgment. And that can be sort of summarized as follows. And the judge basically sort of said, well, look, it's as a matter of English law, there are some basic requirements for me to be able to find there was a contract here. First, the parties have to have reached an agreement. Second, that agreement has to be intended to be legally binding. Third, the agreement has to be supported by consideration, and that's this concept in common law that sort of there has to be some benefit sort of going in both directions. And fourth, any agreement has to be sufficiently certain and complete so as to be enforceable. And to cut a long story short here, the judge sort of reviewed all of these points and says, well, look, I can see that perhaps there could be an agreement here, but ultimately the context of all of this, the drinking, the jocularity, the joking around as between the parties, I find that it's not possible that Mr. Ashley, nor any kind of objective observer would believe that in the circumstances there was any intention to create legal relations. The formality of the environment in that sense was determinative as to finding that there wasn't a contract as between Blue and Ashley. So that is that case. But what does that say about Messrs. Ivanov and Borisov? Because in our scenario, they've at least sketched out some terms, and it isn't necessarily determinative that they were meeting in a restaurant, that this was all in a very informal environment. So as a starting point, and I'd be interested to sort of hear questions when we get to the end, whether people feel that this sort of loan agreement jotted down on the back of a menu would be found to be sufficiently certain, sufficiently complete as to constitute a binding agreement as between Ivanov and Borisov. And as a preliminary point, some questions as lawyers we should be asking, well, 3% interest, is that simple or compound? Quarterly payments, when do the payments actually fall due? Is that are there specific dates? So there is a certain lack of certainty here, but in the grander scheme of things, is it sufficiently certain, sufficiently complete to be a binding contract? So that is sort of our first scenario here. And to recap then on the law as regards to contractual formation, there are few formality requirements as a matter of English law. It's as the judge said in McInnes and Gross, any circumstances, anywhere, in theory. But context is important. And going back to McInnes and Gross, the judge there set out some propositions from the case law at 77 and 78 that might help a judge, help parties assess whether in any circumstances there was an intention to create legal relations. So at 77, judge says there are a number of important principles relating to the intention of the parties to create legal relations. So in particular, one, where there is an express agreement in an ordinary commercial context, the burden of disproving an intention to create legal relations is a heavy one. So if it's been written down, conducted by lawyers in sort of the usual course of conduct, it's going to be very, very difficult for parties to say, well, look, no intention to create legal relations here. However, where there is no express agreement, and thus the onus is on the party claiming that a binding agreement has been made to prove sorry, where there's no express agreement, the onus is the other way around. The party who says there's an agreement has got to prove that. In our case of Ivanov and Borisov, we're sort of in a middle ground. There is an agreement of sorts, but it's going to come down to credit, to sort of evidence at trial as to what was said, the broader context of the meeting, as to whether a judge is ultimately going to believe that Mr. Ivanov believed that he was entering into a legally binding agreement here. So the court may conclude there's no binding agreement because no definite meaning can be given to what was said. And here, again, there are some sort of pointers from the case law. If there's complicated subject matter, it's going to be more likely that the parties aren't just going to orally agree or agree something very brief and lacking in detail. Further, if there is a trigger event, so a condition precedent, that is kind of useful in determining whether an agreement is likely to be sort of found as sort of legally binding, because the parties have, in whatever imprecise and shorthand form, they've identified a mechanism by which performance can be assessed, and then payment, as needs be, can become due. So that's formation. As I say, very few formality requirements, but context is very important to the exercise of determining whether a legally binding contract has in fact been formed. So that is our first area of discussion, formation. But let's go back to the restaurant for a moment. Let's assume a different set of facts. So Mr. Borisov and Mr. Ivanov are still having dinner, and they still agree to a loan. But this time, rather than just sketching it down on a menu, over the coming days and weeks, they get their lawyers to come up with drafts, counter-drafts, proposals that ultimately result in a signed, detailed loan agreement between their two respective businesses, BB Cyprus Limited and II Holdings Limited. These companies, Borisov and Ivanov, are the ultimate beneficial owners, but it's the companies who are the parties to these loan agreements. So one clause in this contract provides that BB will be in default and II will be entitled to sue for the whole debt if more than 14 days elapse after a payment is due and payment is not made by BB. However, that clause further provides that BB will not be in default in circumstances where it fails to make payment in order to comply with what is defined as a mandatory provision of law under the contract. Which is fine. The agreement is agreed, the parties sign it, and months pass, repayments commence. But what happens in the meantime is Mr. Ivanov is sanctioned basically by the US. He becomes what's known as an SDN. Mr. Borisov, in the meantime, is suffering still as a factor of COVID-19, and actually it really help his cash flow if there was a way for him to avoid repayments. So the question here is, can he rely on Mr. Ivanov being sanctioned and this clause as giving him an excuse to stop paying under the contract? Now, before we get to answer that, we have to look at what the law says and how the English courts approach interpretation of contractual terms. Now, in this regard, the most recent Supreme Court case was a case called Wood and Capita Insurance Services, and that was a judgment in 2017, so 3 years ago. And in that case, counsel for the appellant argued that a similarly recent case, Arnold and Britton, which also dealt with contractual interpretation, that the Supreme Court in Arnold and Britton had changed the law, that it rode back is how they put it, but that just basically means it abandoned an approach to contractual interpretation that had previously been set out by the Supreme Court in a case called Rainy Sky. But Lord Hodge, when he gave the judgment of the court, he didn't agree with what the appellant was saying. He said, the recent history of the common law of contractual interpretation is one of continuity rather than change. And to a certain extent, one can say, well, a judge would say that, wouldn't he? I mean, one of the selling points of English law is apparently its certainty, its continuity, the fact that it's a developed body of law that doesn't change radically at any one point in time. But I raise a question here. Is it true? Is it true that Arnold and Britton and Wood and Capita are a reflection of a continuity of approach, or has there been a change as to how English judges approach the exercise of contractual interpretation? In that regard, it should be said that and these are extrajudicial writings, so they're not binding on judges, but they are persuasive insofar that Lord Sumption here, we'll get to his lecture in a minute, but Lord Sumption gave a lecture in 2017. He was part of the court that gave judgment in at least one of these cases, I seem to remember. So Supreme Court judge was giving a lecture as to all of this and whether in fact the law had changed. And Sir Geoffrey Voss more recently has produced an article and given a lecture where he also finds it difficult to accept the proposition that the law hasn't changed. So starting with Lord Sumption's lecture, now what he said is, as I said here, that the time has come to reassert the primacy of language, and that Wood and Capita indicated a new direction of travel by the English courts insofar as the approach they took to interpreting contracts. Now, a bit of context is useful here. And as I said at the outset in my preliminary question, there is a tension in the judiciary and the approach of English law in general as between an approach that favours certainty and holding parties to the words they've used, and an approach that favours fairness, shall we say, favours looking at what would deliver a fair outcome. And in his Harris lecture, Lord Sumption said this: the real distinction, as it seems to me, is not between a literal and a commercial interpretation. It's between an approach to contractual construction which elucidates the meaning of words and an approach which modifies or contradicts the words in pursuit of what appears to be a reasonable result. So that is him crystallizing this tension between the words and certainty and reasonableness and fairness. And he said, well, he said a number of things, and it's a really good lecture that's worth reading in full. But as I've quoted here, he said, it's time to reassert the primacy of language. And he thought that what Wood and Capita and Arnold and Britton were saying is the court had gone far too far in cases like Rainy Sky and a case before it called ICS, far too far in favour of abusing the language of the contract in favour of achieving a just result, to the extent that sort of words were no longer having the meaning that the parties intended. So that's Lord Sumption's approach to all of this. And he's not alone in thinking this. And I've sort of put two references to what Sir Geoffrey Voss, who's the current Chancellor of the High Court, two references to his writings here. And they actually interrelate. So the lecture that's number 2 here gave to the Chancery Bar Association. So he said this. So he said, in Rainy Sky, a two-step approach to contractual construction was introduced. First, the court must identify what constructions of the actual words are possible, and second, it must determine which of them is most consistent with business common sense. In Wood and Capita, this approach was said to represent continuity rather than change, so the point I've made above, which I found somewhat surprising for the reasons I set out in the lecture, Contractual Interpretation. Do judges sometimes say one thing and another? And Sir Geoffrey Voss goes on to explain his surprise. And he says, the reason for my surprise, that rainy sky, as approved in both Arnold and Britton and Wood and Capita, has the effect of bypassing ICS. I say that because the constructions adopted in those two cases were avowedly not possible as a matter interpreting the actual words used, and thus would, if decided again on the basis of rainy sky, appear to have fallen foul of the first step in the new approach, regardless of how much they chimed with business common sense. So what Sir Geoffrey Voss is saying here is essentially, well, look, the judges may be saying one thing, but actually doing another, that there isn't so much continuity here, that Arnold and Britton may in fact represent a return to this primacy of language that Lord Sumption is asserting. And that leads to this question, well, even if the judges don't even know what's going on here, well, how does that help us as lawyers, as advisors to businesses and our clients? How does that help us approach how a court will interpret a contract? And I think, in my view, the best guidance remains that as set out in Arnold and Britton. And Lord Neuberger sort of set out various points here. He said at paragraph 15, when interpreting a contract, the court is concerned to identify the intention of the parties by reference to what a reasonable person, having all the background knowledge which would have been available to the parties, would have understood them to mean, would have understood them to be using the language in the contract to mean. It goes on to say, it does this by focusing on the meaning of the relevant words, and he sets out the relevant provision in that case. And he says, the meaning has to be assessed in the light of 1, natural and ordinary meaning of the clause, 2, any other provision of the lease, 3, overall purpose of the clause, and in this context, he's saying lease, but he means agreement because the underlying contract here is a lease. So the overall purpose of the clause and the agreement. 4, the facts and circumstances known or assumed by the parties at the time. And 5, commercial common sense. But 6, disregarding subjective intention. So this, to me, does seem to align with what Lord Sumption was saying. The number one point here is natural and ordinary meaning of the words. So the primacy of the language. And it's only once you've looked at the meaning of the words in their documentary context, that is to say, the context of the agreement as a whole and what the rest of the contract means by reference to the words it uses, that you can start to look at things such as surrounding circumstances and purpose. So to me, Arnold and Britton is very much focusing back on what parties are using, the words they're using to frame their agreement. So, as I say there in the final bullet, the essence here to contractual interpretation is to look at the words used in their context. So back to Borisov and Ivanov, is it a basis to refuse payment and not default if there's a clause here that says, well, I can not pay if in not paying I'm complying with some mandatory provision of law? And the reason I've used that wording in this talk is that actually this is very, very similar to a very recent case of the High Court in London in Lomas Investments and Synergy Bank. Now, that was a case involving a loan, involving sanctions, involving secondary sanctions risk. And the facts here are set out at paragraphs 2 to 9 of the judgment. And in essence, La Mesa was beneficially owned by Victor Vekselberg. And Synergy was carrying on in business as an English retail bank. It didn't have any real connections to the USA, but like a lot of English banks, it was only able to carry out dollar-denominated transactions by having relationships with correspondents in the US, with US banks. So there was a loan from Lomas to Synergy, and there was a clause very similar to the one that was in the agreement between Borisov and Ivanov that essentially said, well, there won't be a default in circumstances where basically where Synergy in not paying is doing so to comply with a mandatory provision of law. And what this case ultimately resolved to was secondary sanctions risk, and whether the secondary sanctions risk for Synergy if it was paying the loans, i.e. paying loans to a company ultimately beneficially owned by a sanctioned individual, was that something that constituted a mandatory provision of English law, or a mandatory provision of law under the contract, I should say. And so the judge here, and again, it's worth, once the lecture's over, sort of looking at these judgments and reading them in their own terms. And Lomas is not very long either, and none of the judgments I'm citing today are very long. But at paragraph 12, the judge essentially sets out what the legal principles to contractual interpretation are. And he starts off by going through what we've just gone through, which is paragraph 15 of Arnold and Britton. They are the principles that the court must apply. And he goes on to say, the judge goes on to say that where the parties have used unambiguous language, the court must apply it. But where the parties have used language that's not entirely clear, the court can depart from the natural meaning where the context suggests an alternative meaning more accurately reflects what a reasonable person would have presumed the parties to have agreed. So just pausing there, that again seems to be watering down the Arnold and Britton proposition, and again seems to be achieving sort of a measure of fairness and not holding parties necessarily to the strict words that they've used. But that's just an aside there. So what we come to here is an interpretation by the judge at paragraph 15 onwards that takes into account the words used, the documentary context, and also the factual and commercial context. And for the judge in this situation, it was relevant to the interpretation of this clause that meant there wouldn't be a default if in refusing to pay, the debtor was trying to comply with the law. It was relevant to interpreting that it was in the contemplation of the parties that it was possible, albeit not entirely likely, that Mr. Vekselberg would be sanctioned at some point. So that's the context here as well, so playing a part as to what the words mean. And where the judge ended up on all of this was he said, well, look, it might not be entirely clear what mandatory provisions of law means, but in the context of this contract, it was in the contemplation of the parties that there was a sanction risk. Law and regulations as defined terms under this contract were defined fairly expansively. They weren't restricted to solely kind of English law. So he was more than comfortable to say that it wasn't a default for Synergy to refuse payment in circumstances where paying would put them at a secondary sanctions risk, which on one level seems to be a reasonable outcome, but on another you can see how Lemessa would feel hard done by there, because on another level, you could argue, well, look, sanctions aren't a mandatory provision of English law. So, yeah, the reason I'm highlighting this case is that there is always a tricky balancing act for judges to achieve. And interpretation is even now, in this case, not just a case of looking at the words used. Judges will still look to the background, to the context, to shine a light on the meaning of those words. So that's la mesa. Back to the restaurant a moment. What if Mr. Borisov and Mr. Ivanov agreed alone, but there was no term like the term in la mesa? There was no term saying that there wouldn't be a default if refusing to pay was a legitimate act. It was something that the debtor could do in order to refuse, in order to avoid liability under some legal provision. Could, in those circumstances, Borisov argue that there was an implied term that he would be able to avoid payment? Well, in this regard, again, there has been a tension in the case law as to what the proper approach is. And it's worth looking here slightly to the history of all of this, because it's developed over a period of time. And again, arguably, the courts recently have tried to reset the position to a one that was slightly different to the one that had been developed previously. So Lord Neuberger was the president of the Supreme Court for a long period of time. I think he was the president when he gave this lecture in Singapore. And this, again, this isn't a long lecture. It's worth, for anyone who's interested, it's worth looking it up and reading it full. He basically characterizes implication as a gap-filling exercise. So you look first to what the terms of the contract are, and then you see, are there any gaps? And that's slightly simplifying it, because as we'll come on to, the test and the threshold is actually quite a high one. But essentially what he's saying in this lecture is that it had always been the orthodox view that implication of terms was an entirely different exercise from interpretation of a contract. And in support of that, he cited another judge, Sir Thomas Bingham, who said this: the court's usual role in contractual interpretation is, by resolving ambiguities or reconciling apparent inconsistencies, to attribute the true meaning to the language in which the parties themselves have expressed their contract. The implication of contract terms involves a different and altogether more ambitious undertaking. The interpolation of terms to deal with matters for which ex hypothesis the parties themselves have made no provision. And that is a key distinction here as between interpretation and implication, because interpretation is looking at something where a provision has been made and working out what the provision means. And what Bingham is saying here is, well, look, if you're implying, by the very nature of it, the parties haven't made any provision in the contract for this scenario, for this sort of circumstance arising. And Lord Neuberger goes on to sort of outline what the orthodox approach of the law was. And that was something that was known as the officious bystander test, which had 5 requirements for implying a term. First, that it didn't conflict with an express term. Second, that it was necessary to give a contract business efficacy. Third, that it's so obvious that it goes without saying. Fourth, that it's reasonable. And 5, it's capable of clear expression. However, there was an arguable change in the law in a Privy Council case called Belize Telecom. And he made 2 propositions in that case. The first was that those 5 tests weren't actually separate requirements, And the second, which was seen as radical at the time and still is to a certain extent, is that implying a term is not a distinct exercise from interpreting a contract. It's part of the same interpretation exercise. And Lord Neuberger goes on then to set out the various problems with that, the various academic discussions. But the academic, again, as a matter of English law, academic articles can be persuasive, but they're not binding. Where we get to, ultimately, is the recent judgment of the Supreme Court in a case called Marks and Spencer and BNP Paribas. And in that case, Lord Neuberger makes many of the same points that he makes in his lecture. But he tries to, again, reformulate the law and go back to sort of this more orthodox view that the implication is a separate exercise from interpretation. And again, I'm not going to read this out verbatim because paragraphs 14 to 32 are quite a long part of the judgment. But it's useful to note briefly what Lord Neuberger said at paragraph 21. First of all, he says it could be dangerous to reformulate principles, and in this respect, he's talking about the sort of the 5 principles that I set out earlier. But in any event, he says it could be dangerous, but I'm going to add 6 comments. So the first comment, he says, implication is not critically dependent on the proof of an intention of the parties when negotiating the contract. So that's something that's very different from interpretation, where interpretation sets out to look at what the true intention of the parties were by reference to the words used. But comment 1, intention isn't important. It's not critical. The second point, a term should not be implied into a detailed commercial contract merely because it appears fair or merely because one considers the parties would have agreed it if it had been suggested to them. Those are necessary but not sufficient grounds for including a term. He goes on. However, and thirdly, it's questionable whether the first requirement, reasonable and equitableness, will usually, if ever, add anything. If a term satisfies the other requirements, it's hard to think it would not be reasonable and equitable. Fourth, as was suggested in Belize Telecom, although the requirements are cumulative, business necessity and obviousness, the second and third requirements, can be alternatives in the sense that only one of them needs to be satisfied. Fifth point, so I introduced the orthodox test of the officious bystander. The fifth point is it's vital to formulate the question to be posed to the officious bystander with care. And sixth, necessity for business efficacy involves a value judgment. It's not one of absolute necessity, but it's still a high threshold. So going back to Borisov and Ivanov, it seems to me unlikely, if there wasn't an express term and it's a detailed commercial agreement, that the court is going to be willing to imply something in just because either it makes sense or would be fair. That doesn't satisfy the threshold. So that, broadly speaking, is interpretation and implication of terms. I want to turn now to the third topic, which is variation or rectification. And I think, as I said at the outset, these are very sort of separate areas, but in the context of the scenario that we're dealing with, it perhaps makes sense to address them together. So let's go back to the restaurant again. This time, Borisov and Ivanov aren't talking about a loan in the sense they want to make one. The loan has already been agreed some time ago, has been set out in a proper, comprehensive written express agreement. And actually, what's going on at the restaurant now is Mr. Borisov wants to change the terms. COVID-19 is impacting his business quite severely. He wants to sort out his cash flow situation, and he wants to ask Mr. Ivanov, look, can we defer payment? Can we reduce the payment? Is there a way here of changing what we've already agreed? So in this context, they still write down a broad note on the menu of what they've agreed. Deferred payment, reduced payment, however you want to sort of put it. But they seem to be in agreement as between themselves that Mr. Borisov's obligations under the loan will be reduced for a period of time to enable him to increase his cash flow, improve his cash flow. However, once again, as before, Mr. Ivanov wakes up the next day with a headache, too much brandy. And he's regretting agreeing to this variation because his own business is also short of cash. So he doesn't really want to be in an agreement where he's reducing his own cash coming in from BB. So can he get out of this variation? In answering that question, does it matter if there's a clause in the agreement that requires variations to be signed by the parties and agreed in writing? So that's our first set of questions. The second set of questions here. So Borisov's not happy with Ivanov's change of position. And actually, he's going more extreme. He wants to say here that what's on the menu was in fact what was always agreed. It was never the case he was going to sort of be held to the onerous terms. What was always that was just an error. He wants to change the loan agreements to reflect what's on the notes, because he says, well, that's what we always agreed. And that's what we discussed at the restaurant. But hang on, the lawyer's got it wrong. The numbers and the terms are wrong. So we need to rectify our agreement. So there are two broad sort of positions here. On one side, Ivanov wants to show this variation isn't binding on him. And on the other, Borisov either wants to show the variation is binding, or more extreme, he wants to go back to the contract and actually rewrite it such that the variation has effect ab initio. So, variation first. And I asked here whether it's important that there is a clause in the contract that requires any variations to be in writing and signed by the parties. But as a matter of English law, that is important. And again, most agreements I see in practice, that you will see in practice when you get there, if you get there, will have a clause to the effect that states something along the lines of no variation to this agreement shall be valid unless in writing and signed by the parties. And the shorthand for that is essentially no oral modification. So let's kind of look at the law first and then analytically go back to sort of Borisov and Ivanov's situation. So again, a very recent Supreme Court case here in Lord Sumption. And to cut a long story short, the pendulum here, as between reasonableness and certainty, has again swung towards certainty. And here the court, through Lord Sumption, said, in my opinion, the law should and does give effect to a contractual provision requiring specified formalities to be observed for a variation. So we'll analyse in a minute what issues there may be with Borisov and Ivanov and their kind of back of a menu variation. But going on for a minute, because this part here sort of reflects and is sort of comparative as to the position in some civil law countries, it makes reference to the Unidroit Code. So at 16, he says, the enforcement of no oral modification clauses carries with it the risk that a party may act on the contract as varied, for example, by performing it, and then find itself unable to enforce. It will be recalled that both the Vienna Convention and the Unidroit Model Code qualify the principle that effect is given to no or modification clauses by stating that a party may be precluded by its conduct from relying on such a provision to the extent the other party has relied or reasonably relied on that conduct. It goes on to say, in some legal systems, this result would follow from the concepts of contractual good faith or abuse of rights. In England, the safeguard against injustice lies in the various doctrines of estoppel. This is not the place to explore the circumstances in which a person can be stopped from relying on a contractual provision laying down the conditions for the formal validity of a variation. The courts below rightly held the minimal steps taken by Rock Advertising were not enough to support any estoppel defences. I would merely point out that the scope of estoppel cannot be so broad as to destroy the whole advantage of certainty, that word again, certainty, for which the parties stipulated when they agreed upon terms including the no or modification clause. At the very least, there'd have to be some words or conduct unequivocally representing that the variation was valid, notwithstanding its informality. And two, something more would be required for this purpose than the informal promise itself. So pausing there before we get on to rectification. The variation here, arguably, is in writing and it's signed. But is there a problem here as to agency? So the agreement we said earlier was between BB and II. Is it a problem? And we're not going to have time to go into agency today, unfortunately, but I flag it here. Is it a problem here that the beneficial owners are agreeing this? Again, that is going to turn to a certain extent on the wording of any clause on variation. But if it says has to be signed by the parties, and Borisov and Ivanov are not, on the face of it, authorized to conduct business on behalf of the parties, it's got to be done by the proper officers, the directors, etc. There is potentially a defense here for Ivanov to say, well, look, I'm not bound here. This isn't a binding variation. Certainly, if there was a clause and they didn't write anything down on the menu, then that oral variation would almost certainly not be binding. But let's look at estoppel for a minute. Say there was a countervailing obligation, a corresponding obligation under these loan agreements that Ivanov was to carry out. And in reliance on the variation of the loan, Ivanov did something. It performed an act, it purchased something, it did something that put itself at a detriment. Would that be an issue here? Possibly. Sorry, I mean, if Borisov had carried out something to his detriment, possibly, as stated here by Lord Sumption, estoppel can arise as a defence to variation. But that's in a very different context here, isn't it? It's in the context of Ivanov saying, I'm not sort of to be held to this, and Ivanov saying, well, look, I've started performing. You, notwithstanding the formal words here, and notwithstanding you may have a defence under this clause, you can't now rely on that. So that's how an estoppel would work. But again, as professional advisors, we've got to be careful to not put ourselves in positions where we're advising clients that they may have an estoppel type defense. So the essence here is, if the variation was subject to a contractual formality clause, and if ostensibly Borisov and Ivanov had authority to agree such variations on behalf of the parties, then that variation is going to be binding, and Ivanov's headache is probably going to get even worse. So that's viewing it from through the prism of variation. Turning to rectification. Now, this is an altogether different remedy. And again, it's worth looking at the Lord Neuberger lecture here. and he discusses rectification very briefly at paragraphs 32 to 39 of that lecture. And the key point here is that there's a very high threshold, and what is effectively being said is that the contract on its true interpretation doesn't actually reflect what the parties intended. Now, there is a view here. So again, we come back to this preliminary issue as to the sort of reasonableness versus certainty, and there being perhaps some movement in how English courts are approaching all this. And as I say in the second bullet of this slide, there's a view that that Lord Hoffman, it's Lord Hoffman in Chartbrook and Lord Clark in Rainy Sky, that essentially the lines have been blurred here as between interpretation, implication, and rectification. And we've dealt already with interpretation and implication, and that's Lord Clark in Rainy Sky. I won't go into that anymore. What I want to look at is Lord Hoffman in Chartbrook and Persimmon. And unfortunately, the way things stand is that is House of Lords authority, the highest appellate court. It is it's binding authority on the courts below. But that hasn't stopped the Court of Appeal very recently, in this case FSHC, recognizing that the law as it stands on rectification is uncertain and unsatisfactory. And again, I would commend to anyone who is interested in taking the study of this further, there is an incredibly long and scholarly review of the history of the law of rectification at paragraphs 46 to 175. And again, you'll be relieved on a Friday evening that I don't propose to read that out verbatim here. The key point is the Court of Appeal is essentially trying its best against the background of a fairly difficult sort of set of judgments in Rainy Sky and Persimmon. And the reason I say that they're difficult is if Rainy Sky is correct and implication is all about the same exercise as interpretation, then there's no real need for rectification as a remedy, because you're no longer holding the parties to the meaning of the words they're using. You can, via an expansive interpretive exercise, via the use of creative implication, make a contract mean almost anything. So you don't, on that worldview, you don't need the remedy of rectification. That can't possibly be correct. So what the Court of Appeal have tried to do here is formulate a test. And they say that to prove that a document, i.e. a contract, has failed to give effect to the party's true intent, there's either got to be a prior concluded contract in which the terms must be objectively determined, or a common intention communicated between the parties such that it can be shown that the parties understood to share a common intention. So what this is kind of getting at here is, again, there's a high threshold for rectification. So back to Borisov and Ivanov, it's going to be hard for Borisov to show, unless he's got pretty compelling evidence that it was always contemplated that what was on the menu was actually the true intention of the parties. In the context of a sophisticated commercial agreement, it's going to be very difficult. So it's going to be very difficult for Borisov to sort of say, well, look, this is what we always agree. So that brings us to the final topic here. I'm conscious I've been speaking for over an hour. I want to open this up to questions soon. But so the topic of frustration is the one that kind of ties all the threads together really on COVID-19. Because I've read a lot of articles recently, I've read a lot of learned commentary on force majeure and frustration. And the first point to make here is that under the common law, under English law, there is no doctrine of force majeure. So if Baritov or Ivanov or either of them want to say that COVID-19 is an event that allows them to suspend performance as a force majeure, the only way they're going to be able to rely on that as a matter of English law is for there to be a force majeure clause in the contract. And if there is, fine, brilliant. Then we go back to our tests and how we approach the question of contractual interpretation. If there isn't, well, sorry, there is no doctrine of force majeure. You have to fall back on this common law concept of frustration. And what I put here, again, frustration is very, very hard to prove. And the remedy isn't one that's necessarily desirable. So say, for example, the contract that we are looking to sort of, there is difficulty in performing because of coronavirus. Say that that is a key supply agreement, or it's a relationship with a bank, a facility agreement. It's a contract ultimately, in many circumstances, we're going to want to endure. We want it to carry on. Well, frustration, unfortunately, is what you essentially end up saying is, well, look, it's impossible now for this contract to continue. So we should try and put the parties in a position as such that kind of recognises the contract is at an end. And for a lot of commercial parties, sort of destroying the underlying contractual relationship is a step too far. So that's point one. Point two here is the basis for showing frustration. And we're looking at, in terms of Barisov and Ivanov, a loan agreement that it basically he can't perform because his cash flow is becoming constrained. So we look at these bases very kind of briefly. So basically, destruction of the subject matter. So this is kind of more amenable to a supply agreement, a goods agreement, where it's just impossible because either the ship has sunk, the goods don't exist anymore, or some other destruction of the subject matter of the agreement. So that's not applicable here. Some form of supervening illegality. So would it now be illegal to perform the contract such that the contract is frustrated? Again, difficult to see in the context of a loan agreement that the performance of which is just being made difficult by coronavirus. Perhaps we can kind of look at sanctions and frustration by way of sanctions, but that's just not a live issue here. Incapacity or death, well, as far as we know, they may have drunk lots of wine and brandy, but that's not incapacitated them. It's certainly not killed them. That doesn't seem to be available. And then finally, delay. There's kind of a delay that sort of makes performance impossible. And that may well frustrate the contract, but most of the case law here, means you have to stands for the proposition you've got to show a very, very serious delay. And at the moment, we just don't know whether that's the case, because these restrictions may go on for weeks, and they may go on for months. It's unlikely they're going to go on for years, but let's see. But the key point here, and it's a point that again I'm sort of keen to make when I'm asked to advise on this, is frustration in most circumstances for most contractual arrangements that are being troubled by COVID-19 is the wrong remedy. It's the wrong cause of action that you're looking for. What you in fact need to be doing is variation. Going back to that point, look at what terms of the contract exist that govern variation, have conversations with your contractual counterparties, and try to come to an agreement, because that is going to offer a better route out of all of this if you are genuinely a distressed business. So that is basically a very whistle-stop tour of 4 very big, very complex areas of contractual law: formation, interpretation, implication, variation, rectification, and frustration. So yeah, I've been speaking for close to an hour and a half. Close to an hour and 15 minutes. I think I will pause there and open it up to questions in the Q&A. So yeah, people feel free to ask questions, whether it relates to this or to common law or English law more generally. I'm sort of happy to take any questions. Silence. Okay, well,
let's give participants some to think. Maybe you can tell us a little bit about how coronavirus changed your job as a lawyer.
Yeah, I mean, I think the obvious point is we're all working from home. I wouldn't normally give lectures from the guest bedroom of my apartment, but here we are. It makes maintaining sort of boundaries between work life and home life more difficult, and it's increased the advisory stuff. As I say, there are a lot of clients currently in contractual relations. They don't want the underlying business to go down, but the whole situation is causing them difficulty, whether it's rent payments, whether it's inability to source sort of raw materials for producing a good. So it's having an impact on all of us. I've just seen we've got our first question. Is there a significant difference between the reasonableness and good faith concepts? Well, that's a really good question. And it's not settled law as a matter of English law. I should back up actually. So reasonableness is something that is usually sort of assessed objectively. Good faith, there is no general duty as a matter of English contract law to act in good faith. That said, more and more, 2 points, more and more contracts, number one, more and more contracts are incorporating clauses and terms and duties and sort of that say that one party or the other or both will act in good faith. So that's kind of point one. Point two, there is a movement in the case law. I'll say no more than that. There is a movement towards there being the possibility of the common law accepting a more general duty of good faith. That said, good faith is an interesting one to prove, or I should say, the lack of good faith. Lack of good faith is obviously bad faith, and historically, as a matter of English law, bad faith is essentially it's conduct that is sort of below commercially accepted standards. So it's sort of bad behavior in a commercial context. So in a way, good faith is a higher threshold than reasonableness. Reasonableness is just something when you look at a contract and look at the terms, what is reasonable, what's not. It's a lower threshold to satisfy is what I'd say. So hopefully that answers the question. I think yeah. Don't you think? And then we've got a follow-up question. Both enable broader interpretation for judges. Yeah, I think that is true. I think the problem is, and this is where we get into the problems identified and magnified by Lord Sumption, by Sir Geoffrey Voss, other people have written about this. To what extent should reasonableness intrude on this exercise at all? And there was a school of thought, and I mentioned the case ICS, it's not in the slides, so I can provide a link. There was a school of thought for a long time, as a matter of English contract law, that you could rely on the factual matrix. And that what I mean by that is the surrounding circumstances of a contract. And in some ways, you could rely on that as a guide to what the parties meant and intended. And that school of thought is still here. The factual matrix is still pleaded in English common law cases, all the rest of it. But I think what has changed, certainly post-Arnold and Britain, is you can't use the factual matrix to pray and aid of reasonableness, where the words, the natural meaning of the words points in another direction. Reasonableness cannot override the ordinary language of the contract. So I've got another question here. So from Dimitri, clausula rebus sic strantibus. You're going to have to excuse me because my Latin isn't what it should be. I mean, I think basically this is the same point that comes up with frustration. So you're basically asking sort of fundamental change of circumstances, material change of circumstances type point. And I think that comes back to the frustration argument. If there's been a fundamental change of circumstances, the primary point of reference here is what does the contract make provision for? Because in most sophisticated commercial contracts, it's going to be the starting point that parties know what they're getting into. They make provision for various things. Now, obviously, you have things like war, like pandemics, etc., that provide sort of a potential get out. But I say there is no doctrine of force-majeure as a matter of English common law. So you have to rely on what the contract says you can and can't do. And if there isn't anything in the contract, you come back to this doctrine of frustration. And yeah, look, I mean, it's possible to say coronavirus is this sort of fundamental change of circumstances, but it's going to come down to the evidence. It's going to come down to the particular contract in each case. So I don't think there is a general doctrine here that's going to allow you an escape route. Okay, one more. I've got two more questions. So benefits and burdens of common law. I think the benefits, as much as I've been slightly sort of critical of the common law, broadly speaking, it's possible as a lawyer to advise what an outcome is going to be. So as much as the law is in a degree of flux in respect of interpretation, implication, etc., it's kind of a narrow spectrum of possibilities of outcomes. So there is still a certainty that you get with the common law. There's a flexibility as well, because, and I've seen this in arbitrations where there are questions as to whether the proper law of a contract is English law or a civil law such as Russian or the rest of it. And certain civil law jurisdictions do not give parties flexibility. And in a lot of circumstances, a lot of businesses, you want flexibility. So I think that's the benefit. The burdens of common law, I think one of the practical ones is a lot of these cases come down to fact evidence, and let's be honest, English litigation, even arbitration under English law, it's not cheap. It's not cheap to instruct counsel. It's not cheap to. I would say that as a barrister that we provide very good value of money, but I recognise that paying hundreds of thousands of dollars, if not millions of dollars, and waiting a number of years for an outcome is not necessarily satisfactory. And there are civil law jurisdictions that provide much quicker outcomes. So that is to be weighed in the mix. So I think that kind of covers benefits and burdens. There are a couple of other questions that I can probably type an answer to. It's probably easier. Otherwise, I'm not sure. I think, Irina, you suggested you might want to answer something, but otherwise, I think that just about wraps up, unless there are any further questions.
Maybe let's answer the last one by Anna.
Yeah, well, I was going to say, I mean,
for some recommendation.
A better understanding. I can do a reading list, and I think basic books or education. there is a book which the new edition's about to come out, and the author of it is a member of my chambers, but I get no commission or compensation for plugging it. It is genuinely a very good book called Title. I will put that in the comments on contract law. It's actually quite cheap. I'll just type the name of that because it's an odd spelling. It's about, from memory, it's about £30–40, which is about what, kind of $40–45 US. It's a very thick, very accessible, and it actually breaks the law down into all of these various bits and pieces. So kind of we didn't go into the nuts and bolts and the details of formation in terms of agreement, but for there to be an agreement, for example, there has to be an offer, there has to be acceptance, and it kind of breaks it down very modularly into what can constitute a valid offer, what can constitute acceptance, what is consideration, what the case law is. It's a very accessible book. That's a good starting point. I'll have a think. There will be other books in terms of the common law more generally. So Title's part of a kind of an Oxford Classics library. So I think the one for tort law, for example, is called Winfield and Joliowicz, which is, I'm not going to try and type that now, but I would recommend waiting until that is updated, because there have been a number of cases in respect of the economic torts, for example, where the law has moved on a bit, I think, since the last edition. So I think a case called OBG and Allen, which deals with the economic torts of inducing a breach of contract and unlawful means interference, which, again, anyone who kind of intends to practice it with parties with a Russian CIS element, they are torts that you will come across and be expected to have a view on. So it's a good one to be on top on, but wait for that book to be updated. Yeah, I will come up with what I think is a good reading list that starts off with sort of introductory texts and then things for the more adventurous. What I would say is look at Lord Sumption's Harris lecture, look at Lord Neuberger's Singapore lecture, look at the Geoffrey Voss things that I've put in the slides. They are very, very well written. They are accessible, and they give a good legal history of how the law has developed and where it is currently. So I'd recommend those as well. Okay, we've got another question. What should the government in Russia do to create a stable legal system? Well, how long have you got? And I think actually a lot of the steps that are necessary are being taken or have been taken. So we had the arbitral reforms in Russia in 2014, which got rid of a lot of these, what I think were kind of described as pocket institutions. So there is a much better arbitration ecosystem in Russia now than was, a much more robust, transparent ecosystem. And I think what people want and expect in the business community, and you go to places like St. Petersburg International Legal Forum, the things that come up time and time again are, can I enforce quickly? And what are the associated risks? And again, one of the issues that comes up time and time again is there's a low threshold in Russia at the moment to commencing criminal proceedings, and a lot of business disputes involve a criminal element very, very quickly. And look, that has benefits and disbenefits, but I think when you go on the international conference circuit, I think it's a reform that is raised time and time again as to how to encourage investment, to encourage people to use the legal system in Russia and have disputes in Russia. How does the government go about addressing this problem that directors of businesses, people involved in businesses, often find themselves tied up in parallel criminal proceedings very, very easily. And it may well be that the facts warrant criminal proceedings being brought. I'm not saying that they shouldn't be brought. It's just I think there is a perception that they are brought more often than they should be for purposes of leverage, which I say I don't have a strong view one way or the other, but I think it's something that comes up on the conference circuit time and time again. So do we have any more questions? Have I answered everything is the question. Irina, you're the moderator. Ask me more if you need me to answer more.
No, I think for lecture. That wasn't great.
No, I need to go and have a drink of water, or maybe like Mr. Borisov, Mr. Ivanov, something stronger, because my throat's a bit sore now. But I hope you all found that kind of useful, informative. I say it was quite high level, because I tried to cover quite a lot and make it relevant and topical. But my email address is on the slides. Oh, it's not, because I didn't put it on. I will provide my email address. Irina, you've got it. I'm more than happy to answer questions offline if people want to kind of bring stuff up, or if they want further resources. I'm more than happy to answer those questions.
Okay, thank you.
Super. Well, thanks everyone. I'm hanging up now. Have a lovely weekend.
Well, the weekends.